If you didn't know, I am a Justice Services Director and I run the Incarcerated and Returning Citizens Department at Spread the Vote. And today I want to talk about some complexities in two states. We're going to combine it together because they're related in a lot of ways when we're looking at what's been going on in these states when it comes to restoring voting rights to people with convictions, with felony convictions, and the work that the people have been doing and how that's contrasted with some public officials. So, in order to give you some background on rights restoration, first we need to talk about felony disenfranchisement, which is the practice of stripping voting rights away, whether that be for a period of time or permanently from people with felony convictions. This happens in a range of different states. And the reason why it's so unjust is because your voting status, your voting rights depend on where you reside. And as a result, a lot of people just choose not to vote if they've ever served a sentence, and some even if they're in jail, which the case for folks who are in jail and haven't been convicted, they're still pretrial and would still be eligible to vote. So coming back to the two states that we're going to focus on today, earlier this year, not too long ago, earlier this month, Attorney General Mike Hilgers issued an opinion finding that the laws passed by the legislature, by the state legislature in Nebraska, restoring voting rights to Nebraskans who've completed their felony sentences are unconstitutional. Now, this is an opinion that the Attorney General stated after the state legislature already ruled with a vast majority that they were going to restore voting rights to people who have completed their sentences for felony convictions. That exact same day in Mississippi, there was an finding that said that if you've not been convicted of select felony offenses, then you can vote, even while incarcerated and while on probation and parole. That is currently being challenged by the state's Fifth Circuit Court of Appeals, which is also widely known as the most conservative of the Court of Appeals. Now, let's specifically talk about what's going on in Nebraska, how we came to this point, and what the challenges are with trying to resolve this. So, the legislature recently had a bill called LB 20. That bill would eliminate the 2-year waiting period for restoring felony rights to people who have already been released from prison. So the former law in Nebraska enforced a 2-year waiting period, which usually aligned with someone's probation or parole. And that was imposed by a bill passed in 2005 called LB 53. Now, after that bill was passed and was already set to be put into law 2 days before the law change went into effect, the Attorney General Higlers challenged that law. And as a result of that, the Secretary of State halted all new registrations by felons who would have been able to vote and eligible lawfully under the newly passed LB 20. Some background on LB 20, it was actually passed with broad bipartisan support, meaning that a lot of both Democrats and Republicans agreed that the 2-year waiting period should be eliminated, which would bring Nebraska in line with several states like Illinois and Michigan that allow for automatic voting rights restoration immediately upon release. This passed with a 38-6 vote, meaning 38 people ruled in favor of the law change, with only 6 dissenting. They did this in order to address any potential voter suppression, which would impact more than 7,000 Nebraskans. The problem with what the Attorney General did is that it not only reinforces voter suppression in Nebraska, which disproportionately impacts voters of color in a lot of cases, but it also completely undermines the legislative process. The legislature is in place in order to legislate and create new legislation. They are in place in order to not only interpret the law and create new laws that align with the moral and societal goals of the state, but they're also there to validate what should be in place when it comes to old laws that don't really fit societal expectations and new and changing societal norms. The fact that 38 state representatives agreed to pass this law, and it went all the way through the governor, who also agreed to pass this law, and one single person, the attorney general, can put out an opinion saying, you know what, I don't think that this should be happening, which results in the Secretary of State taking actions to undermine the law, is completely unconstitutional in itself. So for the Attorney General to say that it's unconstitutional for the constitutional process of the legislature to pass new legislation, and for that single opinion to undo what the legislature already has in place, what the ball is already moving on, people are already registering to vote and excited about participating in the general election later this year. That in itself is unconstitutional. And so I think it's really hypocritical of the Attorney General to do this. And I think it's really undermining of the Secretary of State to respond in this way by halting new registrations. Now, just because the Attorney General has put out this opinion doesn't mean that it changes anything, but it makes it really difficult for the Secretary of State to continue to process new registrations. And it makes it difficult and confusing for people who have felony convictions to continue to go through the process of registering to vote. There are laws in place that would make registering to vote, if you are not lawfully eligible to do so, a crime, which can result in another conviction. And so for people who've already served a conviction and who are now trying to just readjust to society, they might be de facto disenfranchised as a result of being afraid to go about their legal rights to register to vote because of what the Attorney General is saying. And this is really unfortunate. The legislature has already passed the law, the governor has already signed on to it. It's already been scheduled to go into effect. And 2 days before that date, everything is mixed up, and it's really criminal. It's really criminal of the Attorney General to do something like this and undermine the legislature in this way. So let's look at what happened in Mississippi on the exact same day that the Attorney General pulled this stunt, which happened to be during the Republican convention. So while the Republican convention was happening, um, while the Republican convention was happening, all of these things were taking place. Now, let me just say, when it comes to Nebraska, under current law, you can register to vote if you have been arrested but not convicted. You can register to vote if you've been released on bail or bond and your case is still pending. You can register to vote while in pretrial and released under electronic monitoring. And you can also register to vote if you are in jail and your case is still pending. So even if you did not post bail or bond or receive bail or bond, but your case is still pending, you can still register to vote. And this impacts people who are pre-conviction, which is not addressed here, but I just wanted to outline that for folks. So these are the moves that are happening in Mississippi, again, on the exact same day that the AG pulled this stunt. So just some background. Mississippi is an outlier, especially in relation to its sister states when it comes to its disenfranchisement laws. They have permanent disenfranchisement under the Constitution, stripping rights away from those with select felony convictions for the rest of their lives. And that list of select felony convictions has been expanded. So let's look at that list. This was posted by the Marshall Project, and they have a full list, which can also be found on the Secretary of State's office website. it can be confusing for someone who might have served a felony conviction to identify if their conviction type is on that list. And so that they, as a result, might be disenfranchised simply due to the confusion of having to scroll through that list and figure out what their conviction type is. And some people might just be fearful of accidentally registering and as a result, committing another crime. And so, because of this list and the expansion on this list, a group of attorneys sued in order to challenge this list that they believe disproportionately impacted Black voters, which included 50,000 voters, 59% of which were Black, according to a statistics survey. In response to the suit against the state, the Fifth Circuit Federal Court of Appeals ruled on a 2-1 decision that this law, which was originally passed in 1974, was okay. They said it was fine to disenfranchise people. In March, there was a bill that went through the legislature. It actually passed on the House of Representatives side of the legislature, a 99-9 vote in favor of automatically restoring voting rights to people who were impacted by this. However, the Senate side of Mississippi State Congress dropped the ball on this bill, and it did not make it to the governor's desk to be signed into law. So, what's the significance? Since the late 90s, since 1997, 29 states and Washington, D.C. have decided to expand voting rights for people who are impacted by felony disenfranchisements. This has enabled more than 2 million new voters. In cases like in Mississippi, where folks are permanently disenfranchised by laws from the 70s, a pardon by the governor is required in order to restore voting rights. And a governor pardon, as it relates to voting rights, is extremely rare. The governor pardon is actually the reason why the Senate Majority Leader in Mississippi decided that they didn't need an automatic restoration process because they believed that the individual case by case application process was effective enough, even though that process is extremely slow and extremely rare. Now, felony disenfranchisement, according to attorneys participating in the Mississippi case, and according to the legislature in Nebraska, constitutes as a violation of the U.S. Constitution's ban on cruel and unusual punishment. Now, in general, it is understood that folks who do not have voting rights while serving a felony conviction are actually stripped from their voting rights as a form of punishment, according to many states' constitutions. However, when it comes to when folks are released after they've successfully served their sentence and have been trusted to re-enter society, continuing to strip them of their voting rights beyond that has been determined as cruel and unusual punishment. And due to that, that practice of felony disenfranchisement has been deemed as unconstitutional because it perpetuates a practice that's completely rooted in the Jim Crow era and keep Black voters from going to the polls to cast their ballots. So the evolution of this practice, as we've seen in Mississippi particularly, is quite disturbing. Actions for officials who aren't even a part of the legislative process, like Attorney General Higler, is quite concerning. Now, delays in addressing officials' voter suppressant actions could result in a loss of election participation, especially in the 2024 general election, which has already been deemed as a quite pivotal and critical election. The more stunts that officials like Attorney General Higler, like State Majority Senate Leader in Mississippi, particularly, who blocked the law that would have restored voting rights to more than 50,000 voters in Mississippi. Delays in addressing these types of actions will result in voter suppression of tens of thousands of people across both Mississippi and Nebraska. And a loss of election participation in quite a pivotal election could result in a detrimental outcome for the nation. You can learn more about our program, Vote by Mail in Jail, which services voters who are confined to jails with voting absentee ballot and learning about what's on their ballot at votebymailinjail.org /restore your vote. You can use the tool, the Restore Your Vote tool, which was actually produced by the Campaign Legal Center at that link. Thanks for listening. If you want to take action, and you specifically are a citizen of Nebraska or Mississippi, I encourage you to write your state legislature and let them know why restoring voting rights to impacted citizens is important to you, especially if you are an impacted citizen yourself. Thanks, and I'll see you in the next one.